everyone. This is Mario Simonyan, CEO and founder of ESQgo. And what we're going to be talking today about is baseless IP accusations. So we're going to be breaking these up into three sections. The one for today, we're going to be focusing on trademarks. For next month, we'll look at copyrights, and then afterwards we'll look at patents. So today's about trademarks, which, believe it or not, is going to be the most common ones. So let's first take a look at all three IP branches and see what's what, just for a quick overview. So anytime we talk about trademarks, we're talking about logos, we're talking about brand names, we're talking about slogans, right? Anytime we talk about copyright, anything artistic, think of it that way with copyright. So books, poems, photos, even architecture would fall under copyright. And then when we talk about patents, think about inventions. So again, I've got it in blue over here. Patents protect inventions, trademarks protect brand names, copyrights protect creative content. That's a very simple way of looking at the three branches of intellectual property. So let's get into trademarks. We were sort of discussing a little bit of this before we started the recording, but let's just go over it for everyone else who will be viewing this later. So how can a trademark owner protect a trademark? As many of you guys know, registering it with the USPTO, with the United States Patent and Trademark Office. That's the best way to protect it. Even if you don't register with the USPTO, you still have common law protection, but common law rights are so limited, right? So especially when you're in the Amazon world, you want to make sure you have a trademark. And one thing to know about trademarks is even if you plan on selling a product a year later, you could go ahead and sort of reserve that trademark or that brand name. So it's not like you need to be selling it in order for you to file. You could file it months, even years before you actually start by reserving that brand name. A lot of tech companies and sort of mobile app companies do this because it takes such a long time for them to build the app or create the company that they'll go ahead and reserve one or more trademark names or brand names before they've even launched the idea. So keep in mind you could do that. That's what's called a intent to use trademark application or a 1B application. What does trademark law protect, or what does a trademark protect? Really your brand name, right? Your source of goods. That's really what it protects. Think of it as like your reputation in the industry. That's what it protects. And it gives you the privilege or the right to make sure that no one else can use it. Now, is it a guarantee? As we've seen before when we were talking to a few of you guys, it's not a guarantee, but it gives you that privilege or that right to enforce it. But it doesn't guarantee that no one's going to use your trademark or infringe on it. This says you have ownership of this. Now, if you want to enforce it, that's a separate story. Where are trademarks displayed on Amazon's detail page? So they could be found in several places, right? It could be in the title, it could be in the description, or even their special fields for like brand names. So it could be any of those places. Even in the enhanced brand content, you could also find logos and brand names and trademarks there. Is permission from the rights owner always required to use a trademark on a product detail page? So this is, I feel like three of you guys asked this question, right? There's what the rule is, and there's what actually happens in practice. So the rule is, as long as you have authentic goods that you're selling on Amazon, Amazon considers itself as a quote unquote open marketplace. Now, is that always the case? No, right? But generally speaking, as long as you have authentic goods, you don't need permission from the manufacturer to actually list it and sell it. Again, that's not always what happens in Amazon in actual practice. So the example that we provide here is if you're selling a genuine Apple iPhone, you can advertise it as such without infringing on the Apple trademark, because you're not being untruthful when you say this is a genuine Apple iPhone, because that's what it is, right? And there's several Amazon sellers or several Amazon sellers that sell Apple iPhones or Apple chargers or AirPods, things like that, right? So that's the general rule. Now in practice, that's not always what happens. As a seller, when can I use someone else's trademark in the creation of a product detail page? So now we're talking about when can you actually create a new product detail page, right? And again, the answer is as long as you're selling authentic goods and the listing itself doesn't already exist, then you can go ahead and use it to create the detail page. One thing to keep in mind is Amazon doesn't like duplicate listings. So for example, if there's already a listing for the same product with the same brand name, same everything, Amazon doesn't like it if I go create a second listing. They want all sellers to be selling the same product on the same listing. Okay, so keep that in mind. How can I make sure that I am not violating trademark law when selling on Amazon? So here's a general answer, but I'll get into it a little bit more. So as long as you're buying your goods from a reputable seller or a distributor, someone that's authorized, then you should be okay. But one thing to also keep in mind is the agreement that they may have with you or the invoice may have terms and conditions or a clause in the contract that says you could sell this pen anywhere you want, but not on Amazon.com. A lot of manufacturers, suppliers, and authorized retailers have started using that language as far back as 3, 4, 5 years ago, right? Because they usually have the larger brands usually have authorized suppliers that can't sell on these on Amazon. Counterfeiting. So anytime we're talking about counterfeiting, it's really about fake products, right? I'm sure most of you guys or a lot of you guys have seen if you go downtown or if you go to other countries, it'll be like Adidas, but it's like a B in there, right? Like Abibus. That's what counterfeiting is. So it's not even that you didn't get your product from the right manufacturer or directly from the manufacturer or from an authorized retailer, but this is like a fake product. That's what counterfeiting is. Counterfeiting still falls under trademarks, right? So it's trademark infringement. But that's what the difference is when we talk about infringement is sort of counterfeiting. Think of counterfeiting as like a subset of infringement. Usually counterfeiting courts take a lot more seriously because now it's like you're really trying to rip off the brand and really ruin their reputation. If I purchased an iPhone, an Apple iPhone, thinking that this is an Apple iPhone, and unbeknownst to me, this is actually, it doesn't say Apple, but it's Apple, right? B's instead of P's. And I'm like, you know what? This is a really crappy product. I'm not sure what everyone's been raving about with Apple. I had a horrible experience. Phone malfunctions, it overheats. My kid burned his hand on it, right? So that's why counterfeiting, courts take it a lot more seriously, just like Amazon does. So counterfeiting, I don't care what you guys do, make sure you guys aren't counterfeiting. Okay. So now let's get into a little bit of trademark infringement, and then we'll also take a look at a few examples. So trademark infringement, anytime we talk about this, it really boils down to 2 words: consumer confusion. They don't want you to sell something that is going to be very similar to Adidas, sound like it, and in the same sort of similar product or services. Okay, so that's what trademark infringement is. Anytime you think about trademark infringement, automatically in your head, you should be thinking consumer confusion. Okay. So 4 components or elements you guys should think about when we talk about trademark infringement: unauthorized use. For example, I'm Apple. I never allowed you to sell my Apple products. That's one. Number 2, the products that you're selling under your brand name called Apple, right? Your earphones you're selling is identical or confusingly similar to my product and also my brand name. You're using it in commerce. Now, this doesn't mean that you're actually selling. You could list it and never sell it. And that's also considered infringement because the idea is you were attempting to sell it. You were offering it, right? Maybe no one bought it from you, but you made the offer. And then again, likelihood of confusion, which sort of takes the first or identical or confusingly similar to another level. So if it's likelihood of confusion, then that one element itself usually does the trick and should be enough to bring up trademark infringement. So now let's look at some examples. Now, our law firm name ESQgo, we do have a trademark on that for legal services, right? Now, if someone were to come along and do ESQgo, would that be infringement? It would, right? It's spelled differently, it looks differently, but they're the same services, being legal services, and it's pretty similar. ESQgo and ESQgo is pretty similar. They have the same 4 or 5 letters, and they sound very similar, so that would be considered infringement. Okay, this might seem pretty obvious, but just wanted to make the point. Example number 2 would be, what about ESQgo and ESQit, right? Both of them for legal services. This is actually a real case. We filed a cancellation proceeding with USPTO to cancel ESQit, and we were successful. So we argue that ESQgo and ESQit are very similar, same number of words, pretty similar, and both in legal services, right? So again, that I would argue that it is infringing. Now let's get a little bit more broad. ESQgo for legal services versus ESQgo, same name, very similar design, but they're selling ice cream machines. I don't think we have a chance, right? Legal services are not very similar to a company selling ice cream machines, right? So I would say definitely no infringement there. If any of you guys want to open up a ice cream machine manufacturing company or distribution company with the name ESQgo, there's nothing we can do about it, okay? Just like another example is Delta Airlines and Delta Faucets. Both of them are Delta, right? But there's no confusion. Or Dove chocolates and Dove soap, different companies, no confusion. We're talking about chocolate here, we're talking about soap over there. Another example, now this gets a little bit more tricky. So ESQgo for legal services versus ESQgo, pronounced the same way, I'm assuming, spelled a little bit differently, but they help you optimize your Amazon PPC. I would argue that this is infringing. Why? Right? Number one, it sounds pretty similar. It looks pretty similar. ESQgo and ESQgo, both of them look pretty similar, sounds pretty similar, same number of words. Legal services, our legal services are focused on Amazon sellers. So I would argue that the chances are very high, or it's highly likely that if one of our customers or if any consumer in the Amazon space, Amazon seller space, saw ESQgo for Amazon PPC optimization, I think the chances are highly likely that they may think that we've now expanded into Amazon PPC services. So I would argue, maybe a bit biased, but I would argue that there is infringement here. Here's another example, 7-Eleven, convenience store. I think we all know about it. And then Super 7, I would argue that there's infringement there. Convenience store, both of them are in the same services, and the logo looks pretty similar, right? With the 7, the way it's designed, and with one writing 11 and the other one writing super, I would argue that that's probably infringement. Another example, McDonald's versus McDowell's, right? The golden arches. So I'd argue that this is probably infringing too. And one thing that we'll talk about later on is how these popular brands, these world-renowned brands, get super sort of special protection, where normal brands, unknown brands wouldn't. So we'll talk about that later on too. All right, now there's 2 defenses or 2 exceptions to trademark infringement, and that's fair use and nominative use. All right, so let's talk about that right now. And Amazon does recognize both of these, just so you guys know. So this isn't just relevant in the real world, but also relevant in the Amazon world. So when we're talking about fair use, think of this as a way to describe it. Well, it falls in 2 categories, right? Let's talk about the descriptive fair use first. This is if you're using a trademark word to describe one of your products. So it could be something to the effect of, look, the my computer company, we designed a notebook or a laptop that has very similar features to Apple, right? The design looks very similar. There's nothing wrong with that, with you saying Apple there, right? Comparative fair use would be my iPhone that I've designed lasts 10 hours more than Apple iPhone. Or you know what? My Tesla, if Elon Musk were to say my Tesla goes 500 miles more than the competing electric brand called that Toyota made, right? There's no issue there with using another company's brand name when you're using it to either describe something of theirs or compare your product to theirs. That's considered fair use. That's not trademark infringement, even though you're using their brand name, their trademark without their permission. Okay, so that's fair use. The other one, nominative use. This is where you're saying, you know what, our product is compatible. My charger, my phone charger is compatible with Apple iPhones and also Samsung Galaxy phones. No issue with that, right? The only thing I'd mention here is Amazon has certain language they want you to use when you're saying it's compatible with it. So follow those guidelines. Otherwise, this is fair use, or it's fair to use a trademark in this sense, and it wouldn't be considered trademark infringement. Something else you guys may have seen is I know here in LA, there's a lot of shops that repair Apple phones. So they'll have like the Apple logo over there saying we repair Apple phones or iPhones. Now, not all of them will say that they're authorized shops or authorized by Apple, right? Some will. So as long as you're being truthful, then there's no issue with that, and it wouldn't be considered trademark infringement. Again, with these defenses, the boundaries can be very blurry, and some of them it's going to require some sort of background or legal research back into case law with respect to case law, and maybe there's new case law that came out. So I don't want you guys to say or to sort of think that everything that I'm saying, it may be relevant today, it may be relevant tomorrow. In a week, it may not be relevant. That's just how our court systems work. There may be new case law that comes out. So just keep that in mind, especially with AI. So one of my team members yesterday asked about, what if I use like ChatGPT to create an ebook to sell on Amazon? Would that be considered like, would I be considered as the author? So can I get a copyright on it? And my answer initially, I think some quick research, it was like, no, you wouldn't be considered the author because it's AI or sort of ChatGPT that created it. But again, in a few months or a few years, maybe the courts will decide otherwise, or start breaking up pieces and sort of providing more guidance as far as when is it eligible for you to register it as a copyright and when is it not. But for now, based on what I found as of yesterday, I don't think you're able to do that. So again, law is always evolving. Some common misunderstandings when it comes to trademarks. Sometimes you'll see the TM behind like a brand name, and sometimes you'll see the R. So the rule is, or the law is, you can't use the R unless you've got a registered trademark, right? Now, is it required that you use it once you have a registered trademark? No, but it puts everyone on notice. It puts the public on notice that, hey, this is my trademark. Like I'm looking at my logo over here and I don't see the R, but this is a registered trademark, right? So we don't have it here, but I think even on our website and everywhere else, I think we do have it. So just keep that in mind. TM, anyone can use. If you have any intention of later registering this, your brand name or slogan as a trademark, you could put TM. Anyone can use TM. So keep that in mind. Okay. But the R, only people that have registered a trademark. And then famous brands, special protection. So if you're Apple, if you're Microsoft, if you're Tesla, right? Any of these large global brands, you get special protection. What does that mean? So Apple doesn't make, what doesn't Apple make? Apple doesn't make energy drinks, right? If I were to go start a new company, energy drink company, and put Apple on it, there's a high likelihood that people may be confused and think that this new energy drink is Apple's, belongs to Apple, right? So that's why these larger brands get more protection and they say, you know what, we don't want you guys to use it for anything because they're so well known around the world. Anything they put their name on or you put their name on, there may be confusion. So they get special protection. Keep that in mind. Okay. Is there any sort of rule that says you're famous or not? No, that really depends on the judge and for the lawyers to sort of argue and say this brand is famous, so it should require special protection, special treatment. Okay. And then we've had people talk to my team and say, you know what, I want like a worldwide trademark. There is no such thing as a worldwide trademark, right? Trademarks, just like with the other IP branches, they're jurisdictional, meaning if I registered a trademark here in the United States, it's only valid here. I can enforce it only here in the United States. Someone in Mexico or someone in the UK or Germany can use my same trademark, my same brand name, my same products, and I can't do anything about it unless I go register over there. Now, there is something called the Madrid Protocol, where you could sort of expand your trademark here in the United States and register it in other countries. But again, it still requires you to register it in other countries. You're just leveraging your trademark here in the United States. And obviously other countries can do the same thing where they could bring their trademark and expand it into the United States. But again, they're filing a new trademark. There is no one application you file to have like worldwide trademark protection. Okay. Now, how to seek a retraction from the rights owner. So if someone files a IP complaint and you talk to your attorney or based on what you see, and let's say you're extremely knowledgeable when it comes to trademark infringement, you realize that, you know what, I may not be infringing because I've got this defense, or you know what, this was a silly complaint or it's a bogus complaint. Number one, if the complaining party does agree to retract it, obviously that's going to be the best case scenario, right? And what you would do there is Amazon has updated their process where before we would have to send in a form or have the complaining party send an email with a form. Amazon has now streamlined that. They have here it is actually. This is the new, that's the URL right there. So Amazon has this new process, streamlined process where the complaining party would put in the complaint ID, go ahead and select one of these options. Either they acknowledge that they made a mistake when they submitted the complaint, or they say, you know what, we have now authorized the use of our IP for this product, or just say other, right? So it is a lot more of a streamlined process, but that's going to be the best case, is to somehow negotiate with them. Now, are they going to be really willing to negotiate? Maybe yes, maybe no. I want to say 90-95% of the time, they usually aren't. Can an attorney help? I think a law firm, an IP law firm, can help. Number one, determining if there is infringement or not. Number two, any defenses that you may have. And I think brands are a lot more receptive when it's a law firm talking to them. So I think they're a lot more likely to retract if they are willing to retract. But again, that's going to be your best case scenario. Now,
are they financially liable for losses by falsely claiming counterfeit and doing this and not retracting?
So great question. Actually, you bring up a very good question. So the question is, what if they're filing an IP complaint, but it's completely bogus and they just did it to ruin your business? Yes, there are claims that attorney,
or to control the price of the market so they get all the sales.
Sorry, we're talking about two different things. Let me just answer this question, and if you have another question, you can bring it up. So if a complaining party is filing the IP complaint just to get rid of you, but there really is no legal ground and really no argument to be made that it could possibly be infringing, then would they have some sort of legal recourse, or would you have some sort of remedy? Yes, it's possible. However, it's going to cost a lot of money because now you're going to have to end up in court. So it really becomes a cost benefit analysis. Anytime you're going to court for IP, I think you guys need to budget at least $100,000. I would say if we want to be more comfortable, probably somewhere closer to $200,000, right? Because IP litigation can get very, very expensive. I would say probably patent litigation is the most expensive, and then it's sort of somewhere between, probably a tie between copyrights and trademarks. So that's that. Now, can they file IP complaints to enforce some sort of map policy? Is that what you were saying, Mike?
Yeah, basically, the only reason they do it, obviously, if I'm listing something that they're selling exclusively,
Yeah.
and I just get a bunch of their lost freight, for example, and I list it brand new because it's still sealed in the boxes. Yeah, they don't want competition. They just rather, they know what happened to their items. They know the insurance paid them back, but they know that it's floating. He's got, there's a container floating out there of their product. Someone's going to eventually sell it. So
Okay.
they know it's legit, but they want to call it counterfeit, so it knocks you off, and they don't have to compete with you. They want to sell their products.
Got it. So I'm going to try to sort of boil all of that into a question. So can brands go ahead and use IP or file IP complaints to enforce their map policy? No, they can't. And I think the larger brands, the more serious brands, I think they're less likely to do that. Now, just because you purchase goods and you're convinced that it's authentic, that it comes from them, doesn't make it new. There's something called trademark material difference, which I'm not going to get into because that's a completely whole thing, but a completely different topic and very dense topic. But I'll sort of summarize it this way. Just because a product is in its box doesn't mean it's new. What do I mean by that? I'm gonna go back to my iPhone. My iPhone may be brand new in the box, right? But if I buy it from Joe Schmo down the road, I may not have the option of getting Apple Care on it, hypothetically, right? I may not have that option. And if that's something that a consumer would consider it being material, then there is an argument to be made that it could be infringing, because now the product that I received is materially different than what I would have received if I were to purchase it from Apple, the actual Apple store, or any of its authorized retailers. Completely separate topic, but just want to sort of throw that out there. I'm not going to get into any more detail about trademark material difference, but again, lesson is just because it's new, just because it's in a box, just because it's shrink wrapped, doesn't mean it's brand new. Okay, so there still may be issues there, but the
use like new would be a good way to go, just to be safe.
Sorry, say that one more time.
Listing it as used like new would be good, would be safe.
Absolutely, yeah. Again, I've been in the space for 10 years. I don't think we've ever had an issue with someone listing it as used or used like new and having an issue with it. Yeah.
Right. Okay. There's the answer. Thank you.
Yeah, absolutely. And again, it's an answer to your question and not suggesting you do anything or you don't do anything, right? And that's the lawyer disclaimer, Mike. All right. But yeah, so again, going back to MAP, they can't use IP complaints to enforce MAP, and Amazon doesn't really enforce MAP. They want you to handle, they want the third parties or sort of individuals, companies to handle any MAP issues within themselves. Okay.
Do all your viewers know what MAP actually means? Minimum
advertised price, right? So if I'm a manufacturer and I'm selling these pens, this is my product, and I've got 3 authorized retailers. I have them sign an agreement that says, you know what, you guys can't sell this less than $100. I want all of you guys to sell this for $100. Then we've got a bad actor who comes into the market and is now selling this for $299. They would be violating our MAP, right? So we could go after them. Amazon does not respect that. Amazon does not enforce that. So that's what MAP is.
Technically, if it's a MAP policy, someone can call me and I can sell it to them for $50 as long as I don't advertise that price. Correct?
Say that one more time.
All right. So I have a MAP agreement with a vendor.
Okay.
$100 is what I could sell it for. Advertise it for. That's what MAP is, right? So if someone calls and says, I want it $50, I can sell it to them for whatever I want, as long as I don't advertise that $50. That technically that's correct. It's not, is it not?
I would probably argue no, because you're still advertising. Advertising may not always be like you actually advertising it online or in a newspaper, right? But I think it's got a broader meaning. Yeah.
I see. So someone by me saying it out of my mouth, that is, I'm advertising a different price coming out of my
Yeah,
mouth.
because again, the whole idea behind the agreement is, look, I want all of you guys to sell my pen for $100 and nothing less. That way we all make money, right?
Correct.
And I don't want to ruin my brand. I look at this pen, I've built this brand as in, you know what, this is a high-end luxury pen. So I want all of us to sell it for 100. Now, if we've got, I'm not going to give your name, but let's say we've got Joe Schmo down the road who's selling this for 25 bucks. People, number one, may think it's fake, because why are you selling it for so cheap? And number two, now you're ruining my brand's image. So think of the whole reason, the policy behind the agreement. Okay.
Of course.
Yeah. So going back to IP retraction. So Amazon's got a new policy in place. I think it's a streamlined process. I think it'll definitely help out a lot of sellers and a lot of brand owners too. But if things don't go that way, what can you do? It's the legal route. I really don't see anything else, right? It's getting attorneys involved and having them dig through, having them sort of dissect and see if there's anything there. Can you deal with a brand owner? Can attorneys deal with the brand owner? Yes. Can they deal with Amazon? Yes. And as I mentioned earlier today, it's possible that we could argue with Amazon or negotiate with Amazon that, okay, I'm not going to sell these 5 listings that you are alleging are infringing, but I'll stop selling it, but let me sell everything else. So go ahead and reinstate my account. So that is a possibility. Now, does that mean that it'll be a possibility tomorrow? Does it mean it'll be a possibility next month? Not always. As you guys know, if you guys have been in the Amazon space for a year or more, and you guys have really been into it, you guys already know Amazon's policies change. Amazon's behavior, Amazon's sort of unspoken rules change all the time, right? Without any public notice. So only way to find out is seeing what works. And for example, with us, if we're filing dozens of appeals a day, dealing with dozens, hundreds of clients, we're usually able to spot these changes a lot quicker than someone who is only dealing with their one account, and God forbid they are suspended once a year or every 5 years. So again, go there, or the lesson there is Amazon changes their policies and unspoken rules all the time. So any questions about enforcing IP or looking at IP violations or alleged IP violations or anything to do with Amazon or IP, give us a call, schedule a free consultation with anyone on our team. There is a website, phone number, and also email address.